Hey folks, Denise Howell here. We've got an amazing panel for you coming up on This Week in Law. Jay Monahan is here from Zynga, and he talks about Privacyville and privacy by design. Matt Macari is going to be our personal tour guide to the phone patent wars. Kevin Thompson is here. We've got costume, copyrights, Sopa, and more next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell. Episode 136, recorded November 4, 2011. Patent Thickets and Words with Friends. This episode of This Week in Law is brought to you by Ford, featuring voice-activated sync Applink. Now you can control select smartphone apps with your voice, so you keep your hands on the wheel and your eyes on the road. Check it out in the 2012 Ford Fiesta and at Ford.com/technology. And by Carbonite Business, online backup for your law office. Carbonite Business backs up your computer files automatically and continually and keeps them safely off-site. Try it free at Carbonite.com and get 2 bonus months with offer code TWiL. Hey everyone, you've tuned in for This Week in Law, where we talk about what you're going to be able to do and what folks are going to be able to do to you as you navigate the online world. I'm Denise Howell, and we've got an incredibly fascinating and impressive panel of folks joining us today to help get our arms around these issues. Coming back to the show is Matt Macari, newly of The Verge. Hi, Matt.
Hi, Denise. How are you doing?
Doing great. Congratulations on your new gig.
Thanks. Yeah, it's been fun. It's been crazy this week.
Yes, we've been enjoying the launch and the beautiful new site. If folks haven't checked it out, Matt is helping cover all the legal aspects that come up over at The Verge, along with Nilay Patel, and has done some great pieces already on the ongoing saga of the phone patent wars that we'll get into later on the show. Also joining us for a return visit to TWiL is Kevin Thompson, the cyber lawyer. Hi, Kevin.
Hi, Denise. How are you?
Doing great. How are you doing?
Doing fine. Thanks so much for having me again.
Oh, it's a pleasure. And thank you so much for jumping in. For anyone who's jonesing for Evan Brown and has not gotten their Evan fix in a couple of weeks, he had a conflict last week. And this week, unfortunately, he has laryngitis. So we're really happy that Kevin from the same hometown of Chicago has jumped in and is pinch hitting for Evan this week. Thanks.
I'll do
so
my
much,
best.
Kevin.
I happen to be no Evan, but I'll do my best.
No, but you're a wonderful Kevin. And we're thrilled about that. So, guys, don't get too intimidated or anything, but we've got somebody who's truly a powerhouse and titan of technology law joining us here today, and that is Jay Monahan, who's, I think of Jay as sort of a serial lawyer in the sense more of serial entrepreneur than, say, serial killer a la Dexter, although I'm sure, Jay, you get to clean up your share of other people's messes. Jay has been around the block. Yes? Sorry, I heard something jump in there. No. Jay has been around the block with some very, very interesting companies. He's worked for Disney and eBay and Views and currently is at Zynga. And we're thrilled to have him join us on the show. Hi, Jay.
Hi, how you doing? Hey, Denise, you know, I was thinking this morning, you probably don't remember this, but the first time I met you, I was sitting next to you at an event at Stanford, and I remember looking over in your computer. I said, "What are you doing?" And you said, "I'm working on this, using this new product called Twitter." And that was the first time I had heard of Twitter, and you were just a maven and an evangelist, and now look what you've come so far. It's amazing.
Yes, and I remember being at that conference too. You gave a great talk, and it was fun to be playing around with Twitter, and I think that was either 06 or 07 when we were all up there at Stanford. And look how far Twitter's come since then. Who would have thunk?
Indeed. Exactly.
All right. Well, the legal world continues evolving, and sometimes it feels like it's been, years and years that we've been chewing on the same issue. Sometimes things happen so fast that you didn't, see them coming at all. And one thing I think we've all seen coming is that Righthaven is just not going to be able to proceed with its strategy. It has been hit with its largest fine yet. This may be the largest sanctions award I've ever seen or heard of, although they have gotten lots and lots of fines. $119,488. Kevin, you want to bring us up to speed on what so ticked off a judge against Righthaven this time?
Well, in this particular case, my understanding is procedurally they were, found to, and not be able to bring the case that they had, and they are currently the other side is seeking compensation for their bringing of the case, and the judge in this particular case, awarded costs and fees, as you say, $119,000. It's so certainly quite a fine. I believe that they're currently trying to get out of paying it as well. So that's sort of another side battle ongoing with this particular dispute as well.
Well, I guess if we break it down, it looks like the legal fees aspect is the majority of it, but there are some fines just for their being vexatious, unnecessarily multiplicative, and purposely wasteful. So that's
a good summary.
Yeah, a good chunk of what that number represents as well. Matt, any thoughts about where Righthaven is going to go and whether we're going to hear much about them anymore?
Well, I hope they go away. I guess that's, the biggest thing with this is that they, I think a lot of the fine or the fine was accumulated from the attorney's fees from the other side, because even after there had been some rulings, they continued to require the defendant to pay like $30,000 or some additional amount in attorney's fees. So they just tacked that on to the fine. So they just kind of refuse to give in, and in the meantime, it just keeps building on them.
All right, Jay, any thoughts about Righthaven?
Well, I'm not close to the case at all, but just as an outside observer, I was glad to see a judge cracking down on abuse, and whether you've got trolls on the patent side or on the copyright side, it's already an imbalanced system. Litigation cost alone often compel people to settle cases even though they think they've done nothing wrong. And I think when judges crack the whip, it helps. And it's particularly troublesome because in copyright, of course, you've got statutory damages, and it's pretty easy to establish infringement and then rack up a bunch of statutory damages. And it essentially is extortion, and it's an abuse in the way that it's being done. So I was personally glad to see a judge cracking down on these guys.
Yeah, and isn't it it's a group of lawyers, right?
Yeah, they're lawyers who have tried to have the rights to pursue copyright cases assigned to them. And that's part of their procedural problem, is the validity of that assignment.
It makes it worse. It probably stretches the judge's patience, too, that fact alone.
Mm-hmm. I'd agree with that as well.
All right. Well, Jay, you were speaking earlier, actually not earlier this month. It's already November, guys. I can't believe that. Earlier last month to the San Francisco bar about internet and copyright issues, a really fascinating slate of issues on deck for that panel. Let's see, you guys talked about DMCA safe harbors for hosting, from video hosting to cyber lockers, leaving the safe harbor for the open seas, Cablevision, Zadiva, and storage in the cloud, and lots of other interesting things. And with Zadiva finally giving up the ghost, we've talked about them on the show before. For anyone who missed that, they were a service who attempted to be a remotely located video service, a DVD player in the cloud for you, if you will. If you paid a fee, you could ask for any movie, and they had the actual physical DVDs there, and then they would stream it to you for a number of reasons. They had legal difficulties, and they've finally thrown in the towel and settled. So they will no longer be offering that service. Jay, can you bring us up to speed on the talk? I saw Fred von Lohen was there. It looked like you had a great group of folks, and maybe we'll jump off into our own discussion of these issues.
Sure. I guess what was interesting and a little surprising is we did plan to talk about the DMCA, which I've either spoken about or been at conferences where people were speaking about the DMCA and compliance for, I mean, literally years. I thought, well, how long can we talk about this? We spent better than half of the time talking about daily compliance, red flag, suspension policies, the same sorts of issues that come up year after year, because there are new companies in the mix, new business models that are dealing with these issues for the first time. I continue to believe that the DMCA is an imperfect but very useful tool, a very useful protection for those in the business of hosting content or links. I also think it's a very useful tool for people that own rights and are trying to enforce those rights. And that certainly came through during the conference. The discussion of Zadiva really focused on sort of a trilogy of cases, which was the Cablevision case, MP3 Tunes case, and Zadiva itself. And of course, Cablevision was an extremely notable decision in my mind, because it sort of upends the traditional Hollywood business model of licensing streaming. And in each of these cases, the facts are really critical. In Cablevision, you basically had a remote DVR where the user would basically instruct the remote DVR just as they would the TiVo sitting in their living room, and they could cause it, or it actually did automatically record, and then they could cause it to retain a copy of content. That content would be kept privately for them, and if 100 people wanted the same content, Cablevision would keep 100 copies. So there was copying involved, but the court said there was not public performance. And of course, the only reason you could do it at all was because the original fair use cases found that you can do home copying. And then the MP3 Tunes case came along, which is basically a storage case where you were remotely storing your music. The court also found that that was something that was permissible. There were some more challenging issues with the product that they offered called, I think it was called Sideload or Sideloader, where people would identify links on the web and then cause those to be basically the content copied into their storage lockers. And then there was Zadiva, and where Zadiva failed was, essentially the consumer experience was the same. You would ask for a movie and it would get delivered to you. The problem was not copying, because they had DVRs with discs, so there was no copying involved, but it was public performance. And you'll recall that public performance requires that it be both a performance, which it clearly was, and in this case it was also found to be public. This is very much like the early cases involving hotel rooms, when you could tell the front desk that I want to get a copy of a movie, stream it to my room. And so that result was not actually very surprising. Of all of these, the aspect I think that was the most interesting was in the MP3 Tunes case. Remember I said that in the Cablevision case, the way that they, I think, cleverly complied with the law was by making sure that each user had an individual copy of the content. Surprisingly, in the MP3 case, the service actually did some deduping. So they would identify if somebody had saved the identical content using some sort of hash code or unique identifier, they would actually dedupe and then ultimately keep only one copy. And that is something which Cablevision purposely avoided. MP3 Tunes did it, and the court found that to be all an aspect of copying and storage at the direction of the user, and therefore it was permissible. So I think that's interesting, and I'm sure that's not going to be the last word on that issue.
Kevin, do you think that that Zadiva should have stuck to its guns and tried to wage a full-scale legal battle on the public performance or any of the other issues? You think they would have had any success?
I think they possibly could have, but it's hard to say. The judge did look at that issue and ruled against them in when they granted the preliminary injunction. So it's not like they didn't try to bring that, but I suppose on appeal to could have the Ninth Circuit certainly could have taken a different take on it, as the Ninth Circuit often does. But they gave up on that and gave up and agreed to submit to the injunction. So I guess we'll never know.
What about you, Matt? Do you think we'll see any other sort of attempt along these lines? Maybe not from Zadiva, but from somebody else who thinks that following the Cablevision case, there's some room for some innovative services to be offered here?
Yeah, this is well outside of my area, but I do think that with any of these situations, there's always the right opportunity, and with costs and everything, who knows exactly why, but it could have been a situation where a different party, and you would have got farther up to challenge it.
Yeah, Jay, you were with Views for some time, and I'm wondering what you think, sort of stepping back from all of this, of the video service models that are out there, and the fact that people seem dissatisfied with what they're getting from Hulu, not so much from Netflix, except for maybe along the lines of what's there and what's available for selection. It seems to me that we're seeing these alternatives come up because folks want more flexibility in video viewing. And do you think that there is room for those sorts of business models to proliferate?
I think definitely. I think another way of saying what you're saying there is that people sort of want their content when they want it, where they want it, and how they want it. Right. And I think the thing about the Zadiva business, it was a nice try to get around the normal copyright requirements and the normal law that would apply here. But as a practical matter, it's not a very scalable business. You'd have to have a huge warehouse of people running with disks back and forth to machines, or maybe some master machine. It's not very scalable, even if it had worked. What is scalable and what is the future is cloud computing. And I think the good news is that the MP3 case and the Cablevision case are enabling people to remotely store, rather than buying, a 3 terabyte hard drive at home for all my video. It's potentially good news for the box industry and the TiVos and the carriers, because one of the big problems was how to get the devices into the home. Well, with a remote storage model, as with a business like ours, the storage is now in the cloud. And I think these decisions are entirely consistent with the case law. What's not going to be possible is to take content and stream it to multiple people in the traditional way that constitutes public performance. And that's why Netflix has to acquire licenses. They're streaming it to multiple people, members of the public. And I don't think that's going to change without the industry cooperating. But I think there's a huge opportunity for remote storage of music and movies and photos and all the things that we all love to see at home and all of our devices.
We talked last week about an interesting business out there called Play Later. I think they're going to get written about this weekend in the New York Times, that addresses the time and place shifting aspect of the streaming business. They're trying to let you locally record anything that's being streamed to you, and having captured it, you could then watch it, on an airplane or somewhere where you're offline, or just at another time. And I think they have, they're relying on Betamax. They're saying, we're just another instance of time and place shifting. I think they have their own legal issues to confront, because of the terms of service that govern all the streaming services, that they're going to have to come to terms with the fact that the users are not technically under the terms of service allowed to record or make copies of what is streamed to them at all. So, Jay, what do you think about other ways of addressing that one, or any other ways of addressing time and place shifting when it comes to streaming?
Well, it's certainly, just describing the business model without seeing the terms, it feels to me like something that ought to be allowed as being consistent with the Betamax decision. The second part raises an interesting question, and that's the contract issue. And this comes up in the web as well. Question being, can you, in terms of use, prohibit conduct which otherwise would be permissible under the law, under the copyright law specifically, by fair use or some other means? And I actually, in fact, one of the times I appeared at Stanford, we actually talked about this. And at that point, it appeared from the few cases that dealt with it, for the most part, unfortunately, the answer is yes, that there is quite a bit of latitude for a site operator, for example, to prohibit copying of content from the site, even factual content, which some would say is something which is not subject to protection and should be freely copied. There were a few other examples where there were prohibitions which clearly were prohibiting things that would be allowed by law. The exceptions were rare, and there's one in particular I remember was a New York case where a law was struck down. It involved a software license where there was a provision of the license that said you could not write a review about the product without getting advance permission of the company, otherwise you would violate the license. And that was struck down as being, I guess, beyond the pale. But in many other cases, folks have tried and unsuccessfully tried to strike those down. So I think that raises an interesting question of whether they could contractually prohibit something which fair use would allow. I hope the answer is that they can't, but I think that case still remains to be seen.
Yeah, absolutely. Matt, any thoughts on streaming or cloud storage before we move on to other things?
No, I think you guys have nailed it. It's I feel bad that I'm not really able to speak on it very well, but
no, don't worry. We have plenty to discuss with you, Matt. we need your help and guidance in just a minute. But let's just close out this topic. Kevin, any final thoughts?
I think you guys have done a great job, covering this as well. I'm certainly interested in how that contract issue is going to shake out as well.
All right. Well, we'll keep an eye on that. Matt, we do want to have you be our tour guide to the morass that are the phone patent wars in just a moment. But before we get to that, I want to thank our first sponsor for the show, and that is Ford. And I have a really concrete example of why the technology discussed here in this ad is something that's vitally important to people's lives. We're talking, of course, about Ford with voice-activated sync Applink, which enables you to control select apps from your smartphone with simple voice commands while keeping your hands on the wheel and your eyes on the road. You can do things like voice control Pandora in your car. You can listen to your tweets with open beak. Open beak, how great is that? Just by asking with a simple voice command. So I'm driving down the road the other day. I've got my iPhone in hand. I'm talking to my mom. Of course, I'm not able to control anything more complicated than that with my iPhone because I don't have Siri yet, but I'm looking forward to it. Anyway, I've got my headset on. I live in California, and we're required to use hands-free devices when talking on a phone in the car. But I got pulled over. And it's because apparently just having your headset on is not enough. And I did not know this. And so, word to the wise in California, it has to be a headset that only occupies one of your ears. So if you have both earbuds in, you're out of luck. But with Ford Applink, you're not only, you don't have to worry about a headset, but you don't have to worry about one ear, two ears, anything else. Once your smartphone is linked to Pandora, for example, you can use voice commands straight from your car to select your favorite station or make a new one. You can bookmark songs to purchase and give songs a thumbs up or thumbs down. Some of the voice commands include play station classic rock, bookmark song, thumbs up or thumbs down. And with OpenBeak, for example, you can simply say read timelines or read replies. Sync Applink is built on an API platform that allows Ford to continue to work with developers in the app community to bring apps to life with voice in their vehicles. Voice-activated Sync Applink is available in the 2012 Ford Fiesta. You can learn more about this and other technologies Ford is bringing to its vehicles, including Wi-Fi in the car, which I think is just also phenomenally useful, at ford.com/technology. And we're going to bring you a TWiT Sunday barbecue, courtesy of Ford. Ford is helping bring us together at our studio upcoming barbecues scheduled for Sunday, November 13th and Sunday, December 4th. They start at 1:30 p.m. We'll have the chance to meet, eat, and maybe check out some new Fords too. And you'll have seats to watch us record TWiT live in the studio. If you'd like to join us, please go to twit.tv to request tickets. We'd love to see you there. And thanks so much to Ford for helping us bring these TWiT Sunday barbecues to our wonderful viewing audience. All right, Matt, so much has been going on, and it's so hard to keep up with. There are 30-something lawsuits now pending over smartphone patents among and between the players all over the world. Can you just, in a nutshell, give us the highlights of what we need to know right now?
Wow. That's, I'm actually going to work with Nilay on a piece that kind of brings the Apple-Samsung case, kind of brings it together, because that's the most complicated one. And it's the one that's most interesting because I think, it's the two biggest players and they're going at it the hardest. So with regard to Apple v. Samsung, there is a ton going on, but kind of the big areas right now where the fight's been occurring is in the U.S., up in Northern California in federal court, and then over in Australia, and then to some extent a couple of smaller battles that have been meaningful but not quite as large in Europe. So what really happened was, from the beginning you just had the situation where Apple went after Samsung, was it April, I think it was, and for infringement, and we were on the show actually, and Nilay had that piece on kind of summarizing what that case was, and then immediately after that, Samsung, they went all out, around the world, Japan, France, throughout Europe actually, and then Australia is really it's been an interesting battle there. That's one where they've actually obtained an injunction. Apple's obtained an injunction, a preliminary one at least, against Samsung on the Galaxy Tab 10.1. So that one's been oddly, I wouldn't have thought that, but the system moves much faster there in Australia. So we've seen a lot of these issues come to a head sooner than we did in the U.S., which in the U.S. the case is obviously of big importance to both companies, but it's moving quite a bit slower. Although the real key here is that in the U.S. you have a situation where Apple has a preliminary injunction pending, and any day now we're going to actually get the ruling on that from the court. We just haven't received it yet. But if that one comes through, kind of the way it's going right now, it's likely that it's not going to be quite as devastating to Samsung as some might think, because it looks like the court's leaning towards possibly not granting the preliminary injunction. And you're talking about several products there. Besides just, we're in Australia, you're talking about the Galaxy Tab. Here in the U.S., you're talking about some smartphones as well.
So down in Australia, it looks like Apple took some steps to bring together its defenses. You wrote about this on The Verge, so that they make more sense. Can you tell us about that?
Yeah, they've done it throughout. I think if you go back and look at that piece by Nilay, and we talked about it on that show, I don't know if you can hear my 6-year-old in the background there. The case that Apple's presented on their patents, they have a clear case where there's a lot of there's some design patents, especially on the preliminary injunction side. That even the full utility application or patents are directed to more of the UI features, which people tend to understand, even if they are against them. It's more understandable. The countersuits that we've seen from Samsung and even the offensive cases they filed by themselves in other countries are really focused on these more complicated wireless baseband patents. And because of that, there's been a huge dispute over raised by Apple and throughout the blogging community and just about every media outlet there is about how these patents that Samsung are asserting are patents that they're obligated to license under fair, reasonable, and non-discriminatory terms to anybody in the field, basically because they're part of this essential wireless standard that everybody can practice. So Apple's really latched onto that, and what they've done is they've taken the whole that whole defense, which has been pretty solid, and it's actually won them a victory to defeat an injunction in The Hague. They've kind of brought that together and they've harmonized it with their cases around the world, and they're doing that kind of step by step. So their defense is pretty solid. We'll see how it plays out in the different countries, because some of the wireless standard bodies that we have around the world aren't always going to be consistent. But for the most part, it's pretty universal. So Apple's really got a decent strategy together. So what they're doing is they're just kind of simplifying everything, and they're bringing all that together throughout all their cases. And a lot of it's based on that victory they had in the Netherlands at The Hague, because I think it really gave them a little bit of ammo.
Right. I'm sure you paid attention, Matt, both over at your Litigating Apple blog and now while you're at The Verge, to what might go on strategically now that Steve Jobs is sadly out of the picture. He has now rather notoriously, in his biography that was just released, talked about spending his last dying breath fighting Android. Do you think that there might be a strategic shift now that we don't have that kind of vehemence at the top at Apple, or do you think that these strategies are set in stone and are going to continue?
I think somebody asked Tim Cook recently, I don't know what it was, where I saw it, but that, kind of what his position was on this based on, I don't know if it was directly related to the statement in the Jobs biography, but in reality, and I think he just avoided answering it. But in reality, I think obviously the initiation of the suit and whether or not it's going to settle is directed from the CEO in many ways. But I think when it gets down to the real nuts and bolts of the litigation, a lot of that gets lost, and it becomes more of a pragmatic approach. And I'm not so sure that that overriding theme of thermonuclear war is really there. I think in reality, if you really want a thermonuclear war, you would sue Google. That would be a much bigger opponent. But Apple did what they did very strategically because they want to file these ITC suits and things like that. And there's a definite advantage to going after the OEM manufacturers when you're talking about products coming into the country. That's the real way to stop those things. And I think the initial suit, kind of the spark to get it going and all that, is very much probably related to that feeling at Apple. But I think in reality, it's something a little different now.
Well, speaking of suing Google, there's an interesting article over at ZDNet about Apple's on-off switch and the patent that they have in that. And they're speculating about whether Apple would ever really sue Google or Microsoft for infringing that patent. What do you think about that?
Well, they won't go after Microsoft, and Apple aren't going to butt heads again. I'm pretty confident of that. First of all, they have a pretty generous cross-licensing agreement, and that's part of why we saw the Nokia settlement, I think, so with Apple. As far as going after Google, I've thought about this a lot, and I just think it comes down to the real impact and what they think they can change, and that they're really trying to eliminate some of these products from the market. Whether they're far from getting there so far, but I just don't think that they really want to take on Google, and I don't know if I know the answer to why exactly, other than the fact that it's clear they don't, or they would have. I mean, it's one of those things that, but as far as Microsoft goes now, those two have already had their battles, and they've kind of come to an agreement, I think, that they're not, Apple and Microsoft aren't going to battle anymore.
Well, I'm not a patent attorney myself, Matt, but some of the commentary that I've read suggests that some of the reasons that they're bringing these suits against the OEMs is to try to get some wins before they turn their sights on Google. In that they want some wins, showing that they're going to be successful before they try to take on the operating system themselves.
Yeah,
what do you think about that?
Yeah, that's a theory. I don't agree with it. And part of the reason, it's just the realities of the patents. Some of these patents they're asserting just cannot be easily enforced against Google, because a lot of these aren't pure software patents that relate directly to how the Android is functioning or the methods of how it's used. Some of them are combinations or hybrids of hardware and software patents, or software claims within a patent. So it's not as easy to bring in Google on those issues. And one of the reasons it's not as easy, because then you have to make up arguments. You have to come up with arguments for indirect infringement. And you have to combine parties to get all the limitations of the claims. And those things are much easier to do when you're talking about a hardware manufacturer that has all of that in their device that they're selling. So it's all cohesive within one device. I just think the reality is that there's just really no desire. They just think they have a realistic plan, and they have a better chance at going after something when it's based on a product. And some of these things are obvious. There are some patents in there that they could assert directly against Google, but I've thought about it a lot, and I actually don't know the answer to it. It's a situation where I think they're avoiding it, and that much I know.
Yeah.
Well, Matt, here's an example of a little guy getting the drop on Apple. Virgil in IRC points out that NTK has managed to get out from under, having its shipments from China seized, its name temporarily placed on an EU-wide list of product pirates, and Apple, being they, even brought commercial charges against NTK. But all those claims have been dismissed, and now they're coming after Apple for antitrust.
Yeah, that was I wish you had a picture of that NTK. I don't know, tablet. It's not an iPad by any means. Mm-hmm. That is a funny case where I think Apple got greedy, and they went after a small manufacturer in Spain who operates Android on the tablets, but the tablet looks nothing like an iPad. It's rather clunky looking. It's much thicker. It's got some ports on the side. If you look at it from the front on, maybe it has a resemblance to the iPad in that it's rectangular and it has the screen, but the profile on the back are just completely different. So that was a case where I think Apple pushed its luck, and it doesn't bode well for them if they have more of those cases like that out there. It's certainly not the Galaxy Tab 10.1. It doesn't have any resemblance to the iPad at all. And they rightfully lost. I mean, there was the situation with there was actually criminal charges involved for piracy, which relates to the customs and who they were blocking at customs coming into Spain. And that's a unique area of the law for that country, so I'm not really sure how it played out. But my understanding is it wasn't quite as bad as Apple was trying to put these people in jail, as much as there was some sort of initial process started that was never followed up by Apple, and that was dismissed. And my other understanding is that the case is potentially not completely dead, and Apple could still bring a preliminary injunction, but my guess is they won't. and they'll let it go and now try to deal with these anti-competitive charges that the company's raised against Apple.
Great. Well, thank you for the update on all of that. I'm sure that folks will continue to follow you and Nilay over on The Verge as you continue to well cover this issue. There's also a great article over at The Deal for anyone interested in more detail and analysis on this sort of morass of stuff. It's got a great title, Trolls, Geeks, and Lots of Lawyers, talking about where we are in the patent litigation arena right now.
Denise?
Where we, yes.
I was going to, this is Jay. I thought I might just add something. After hearing all that, I felt like I should say, meanwhile, back at the ranch, is I actually live in a very different world, having worked basically on internet-based companies for the last 15 or so years. Lawsuits between competitors are actually extremely rare. I mean, there's the or even having web companies assert patents in this space are rare. There was, of course, the original Amazon one-click case. There were some cases that Yahoo inherited involving overture and keyword buying, but they're pretty rare. And even in my experience going all the way back to eBay, the vast majority of lawsuits we faced were non-practicing entities, and that remains true today at Zynga. Every patent case we have is a non-practicing entity. They're all in Texas or Delaware. There's no real company to go against. Hopefully and fortunately, our Merck Exchange injunction standard case will be of some assistance there. But it continues to be a serious problem for those of us in this business. We did get a little bit of help, not a huge amount, but a little bit of help in the recent patent reform decision. One thing in particular that's worth noting that will be interesting to see how it plays out is the Joinder Rule. It's no longer possible to basically identify a patent or several patents and just name a whole bunch of companies in one lawsuit that infringe. And not unsurprisingly, or not surprisingly rather, just prior to the effectiveness of the new Joinder Rule, there was a spike of filings of multi-defendant cases that basically are grandfathered in. And then immediately after that, there was a reduction. There were more cases filed, but of course they had single defendants. Unfortunately, what I'm now sort of hearing and seeing is lawsuits being filed against different defendants in the same jurisdiction, trying to low number them to the same judge, and then basically trying to have the same result, albeit in separate lawsuits. So we'll see whether this actually does deliver any relief. It may or may not, but I'll take any help I can get at this point in fighting these bad guys.
That's great, Jay. And what happened exactly last summer, wasn't it, with Merck Exchange? Didn't something become final that is helpful?
No, I think that happened quite a while ago. For those who may not be familiar, the Merck Exchange case, eBay was a party. There was a trial verdict against the company, and the judge declined to issue an injunction. That eventually got reversed by the Federal Circuit. It went to the U.S. Supreme Court, and eventually the Supreme Court agreed with us, basically finding that injunctions do not automatically follow from a finding of liability. And this was huge for those of us that deal with patent trolls, because patent trolls, by definition, almost never have a real business. So their real reason for doing this is money, not to protect some existing business. And over the years, it has played out in a way that has been, I think, the appropriate result, which is that there are a few cases where injunctions have been denied. In the cases involving real companies and real competitors, they continue to issue. What you may be thinking of is that the same principles from the Merck Exchange case have recently been cited in copyright cases, which again, the law, all of these laws sort of steal from each other. The same is true when you talk about patent inducement and Grokster. They all sort of look at each other. So it makes all the sense in the world to me that the statute
Colin, did we lose him?
Where the Federal Circuit had virtually always, regardless of the circumstances, and that was reversed in the case. So another weapon to use against non-practicing entities. It restores a little bit of the balance, but I think we still have a long way to go.
Yeah, can I comment on that? Because I think that's a good point. The when that eBay case came down, it was a lot of patent attorneys and patent litigators were up in arms, and I think a lot of it was because they'd enjoyed some sort of presumption throughout the years that if it's a patent case and you win, you automatically get an injunction. And on the beginning of the case, they felt that it automatically gave them an edge to get a preliminary injunction. So I think that the decision really made a lot of sense, and how it's played out throughout, since then has been pretty reasonable. It's been the cases where you get an injunction, and you get a ruling, and it's not automatically a given that you're going to get one of these injunctions. And the factor is that if you're talking about somebody that's not competing in the market, then that's an important thing to think about, because it is really damaging to have somebody basically shut down without having a competing product in the market or some service in the market that would take that place. And so it's played out on the preliminary injunction side too, which is where I think it affects patent trolls or non-practicing entities, whatever you want to call them, is that they're not as likely to get that preliminary injunction at the beginning of a case, because it's proven and it's established that these companies don't have a product, so money is good enough. And if money is good enough, then there's really no incentive. There's no reason that a preliminary injunction should be automatically granted, or should be more easily granted in the case of a patent suit.
Denise, can I add on to that?
Sure.
One of the interesting things about the case, if you were to read the decision, is there was a majority opinion that everybody signed on to, and Justice Thomas actually wrote the opinion. There were then two concurring opinions that were sort of on polar opposite sides. One basically said, essentially said, whoa, everybody slow down here. Yes, this is the ruling, but in the vast majority of cases, injunctions are still going to issue. Don't get too excited about this. And then on the other side, there was a concurring opinion that was, I think, influenced by certain amicus briefs, including from companies like Intel, that had complained about what they called patent thickets, where you would have one small product that might have 100 patents that read on it, or the problems of an ingredient patent where you've got a product with lots of moving parts, literally or figuratively, and the patent covers one small element. And the argument was that if you allow an injunction, you are causing vastly greater harm by essentially stopping the entire product because of one small piece of it that holds the whole thing hostage. And in the phone wars that we were just talking about, I can imagine those arguments being made. That said, I'm not aware of a case following Merck Exchange where that reasoning was the reasoning for not granting the injunction. They may be out there, and I may not be aware of them. The cases where the seekers of injunctions have lost have been, you're not practicing, you're freely licensing, there's no argument that you need exclusivity, which were basically the reasons that were cited in the majority opinion, and in fact were the facts of the Merck Exchange case itself.
Yeah, that's right, yeah.
All right. Well, thanks so much for that, guys. That's really helpful and clarifying and crystallizing of the issues. I want to, in a bit, talk about Sopa, which sounds fun and maybe like something from Brazilian Carnival, but is not so much. And also get into what's been going on with Jay at Zynga. But before we get to that stuff, I'd like to thank our other sponsor for this episode of This Week in Law, and that is Carbonite Business, which is online backup for your law office, or any office for that matter. I use it for my law practice. Carbonite Business backs up your computer files automatically and continually and keeps them safely off-site. You can go ahead and back up your computer automatically for just $229 a year. It only takes about 10 minutes to get started. more and more law offices are backing up a better way. I remember the days when we would have, our own little server farm kept in a cold room somewhere in the office, keeping everything backed up that way. And of course, you do want to back up locally too, but you can't be safe unless you're also taking precautions against there being a catastrophe there in your local space. So you've got to back it up online, but off-site as well. And there's no better way to do it than with Carbonite Business Online Backup. You can try Carbonite Business free at carbonite.com, and when you do, you'll get 2 bonus months with offer code TWiL, TWiL. That's carbonite.com, offer code TWiL. Thank you so much, Carbonite, for your support of This Week in Law and the TWiT Network. All right, so let's talk about Sopa, which is the house version of Protect IP and is much less fun than it sounds. It also, and I can't really tell from the coverage I've been reading whether this is seriously the name that the people backing this law are calling it. The E-Parasite Act, I can't imagine how anybody thinks that would be a good law to pass just based on its name, or if that's the name that its critics are calling it, because that seems to make more sense to me. But I think if it is seriously being called the E-Parasite Act, it's alluding to the fact that anyone who is engaging in infringement is a parasite on our business economy. Jay, you have been tweeting about this, and it seems like it's taken Protect IP and made it even less palatable, if that's possible. Do I have that right?
I think that's probably a fair statement. Let me preface my comment by saying that my point of view on this is informed by quite a variety of experiences, having been on all sides. I mean, early in my career was an anti-piracy lawyer for the Walt Disney Company, and then of course went to eBay and dealt with intermediary liability. Views, my former company, among other things, distributed and still distributes a BitTorrent client as well as other products. And now, of course, I'm in the game business, so I've been on all sides, and I have been an enforcer, but I also am acutely aware and acutely sensitive to attempts to impose liability on the wrong parties or to shift the burden of enforcement, as well as the unintended consequences of legislation. So with all that said, I agree with many that have commented on it, that this legislation, and particularly the House side, is very troubling. Certainly the idea of going after massive infringers of copyrighted works is a legitimate objective, but we in the United States, have had the benefit of the Digital Millennium Copyright Act, which provided a sort of a sane, rational way for rights owners to easily enforce their rights to the extent that content is hosted on servers or there are links and the like in the U.S. And it struck the right balance. It has some protections, and it's worked pretty well. These rules and the current law has not enabled copyright owners to get at all the problems they would like. I really do see this legislation as an end run around a lot of principles, including the principles of the DMCA. There are 2 parts to it in the House version. One involves the enforcement rights of the Attorney General, which I believe are limited to accessing websites that are so-called foreign sites, which means the domain name is not .com. It would be .ru or some foreign domain name. The standard, which is I think what troubles most people for designating a site as sort of being dedicated to piracy, includes sites where all or a portion is committing or facilitating piracy. So if you think about that, you could have a portion facilitating piracy. It can be a very indirect relationship. The website operator might have no knowledge of it, and if they do, it doesn't have to be the whole site. The remedy involves actually cutting off or instructing ISPs to cut off the URL so it's no longer accessible in the U.S. The law also has a side for civil enforcement, and I believe this part is new, and it is tempered in the sense that the remedy doesn't include blocking URLs, but it does enable the rights owner using a DMCA-like notice procedure to get an advertiser or a payment site like a PayPal to actually remove the service. So, and I think the theory, of course, being that if you're offering something unlawful or potentially unlawful, if you can cut off the ability to pay, you can basically kill the site or cause it to suffer and shut down. And if you think about it, and by the way, this is not limited to foreign sites. It can be any site that appears to be dedicated to the theft of U.S. property, I think is the language. And the opportunity for abuse of that definition seem rife to me. I think this is another effort to basically sort of, as they would say, cut the snake at the head. I really worry about the unintended consequences and the abuse of websites that have a portion, knowingly or unknowingly, involved in piracy, using a procedure which is essentially, it's not an adjudication. The DMCA notice in the U.S. is not an adjudication. It's basically an allegation. The problem is, from a practical point of view, if you're an ISP receiving notice and you know that you have basically complete immunity in compliance, most of them are going to comply, which means the benefit of the doubt goes against whoever the website is, and you end up having websites and or content or payment services taken down. So it's troubling, and I think you're going to see another round of reaction to this that has already started.
This is incredibly interesting, because automatically you start thinking about the kind of the manipulation of it. Are a lot of the concerns dealing with these comments and forums and things like that, where things occur on websites that aren't being controlled and generally don't define the overall site, but where some of this activity might occur?
Well, I mean, I think it's unclear. I mean, it's a pretty vague definition. I think the target is probably websites like RapidShare that store large quantities of content, much of which is believed to be infringing, and they've had mixed success at this point in getting those taken down. By the way, I've neglected to mention that the standard, if you do a report for the civil side, that the standard for liability is you have to knowingly materially misrepresent that the site satisfies the definition, which means if you are wrong, even recklessly wrong in reporting, you have no liability. And unfortunately, this is also a problem with the DMCA itself, that has a standard of knowingly false report before there's any liability. So there's no incentive to be that careful in even submitting these reports.
Wow, this does sound fairly terrifying, and it sounds like it's driving a cement truck through the exception in Communications Decency Act Section 230 that carves out intellectual property violations from the immunities that provision grants to website operators, that they're already vulnerable on that front, and this takes that vulnerability and turns it into something quite terrifying. Kevin, do you have any thoughts on this?
Well, I think in addition to those comments, I think there's, Section 103 of Sopa, not only goes against the website itself, but it's trying to go against the payment processors as well with this notice and takedown provision. It's like they're further expanding the groups of people that this law is going to be applying to, and they're finally getting to the point where they're going to be able to do what they want to do, which is go against some of these foreign websites, which, they're getting money through the United States, such as Visa or MasterCard, taking MasterCard payments. And, MasterCard's going to get a notice that, this site is infringing, and they're going to be, get their money taken away. But I can also see a lot of abuse as well, that particular provision. So it's certainly problematic. I just think in general the principle is good, but I think it's just way too overbroad. And I personally I'm quite concerned about, whatever version of this, if it even comes close to getting passed, I'll be very concerned.
Yeah, it's shaping up to be quite... Go ahead.
I would say, I'm sorry, I think it was a little delay there. I was going to say it's worth noting that specifically with respect to payment processors, that the one, I think, most recent case, it was involving Perfect 10, one of the many Perfect 10 cases, and Perfect 10 was trying to do exactly this, which is to impose liability on payment processors. I think it was Visa and MasterCard. Same argument can be made for PayPal, and there the court said, no, we're not going to do that, even if there is infringing activity going on, the relationship between the payment processor and the infringing activity is too attenuated to justify imposition of liability. This clearly overrides that. If somebody is willing to say in a simple form that this site's dedicated to piracy or facilitating beyond some standard that's vague, all bets are off. And the payment processor, as I said, has little incentive to resist, because if you resist, you face potential liability. If you go along with it, you're immune.
Wow. It looks like it's going to be quite a policy battle as this thing wends its way through consideration. Declan McCullough has a good article about this, and he points out that EFF, the Computer and Communications Industry Association, which has eBay, Facebook, Google, and Yahoo as members, among others, Public Knowledge, those are folks all lined up saying this is a very bad idea. But on the other side, and Declan fears that they will be outlasted and outspent by the forces on the other side. We've got the National Music Publishers Association, the U.S. Chamber of Commerce, and the MPAA, and a dizzying array of organizations touting the bill as a way to save U.S. jobs. So there's a hearing on the bill scheduled for November 16th to stay tuned for. There's also one of those White House petitions at whitehouse.gov. For anyone who has concerns about this bill, you can voice those concerns to the White House by signing that particular petition. Matt, any further thoughts before we wind this up and move on?
No, it's very interesting. You just mentioned that petition site, and I'm actually writing something about that, because there's the same petition. I mean, they're on all subjects, but there's another one out there that they did on stopping software patents that garnered a response from the White House, I think this last 3 or 4 days.
Oh, really? What did the White House say?
They said nothing.
It's not our fault.
Yeah. There are a lot of words, but essentially they said, they said two things really. It comes down to, the Patent Office. I mean, the new patent reform law, the American Invents Act, is going to fix it all, and without really explaining how. And then they also said that they're involved heavily in government in promoting open source technology. Or they call it open source energy. So really, they didn't say anything, and I think they had 15,000, just shy of 15,000 signatures on the petition. So that I saw. It's interesting, this whole online petition thing. But when I saw that response, it really made me put it in perspective of what it really is. And I'm not sure it really has any value at all. But it's an interesting activity, at least.
Yep. I think it's good PR for the White House, and it makes people feel like they're getting their voice heard. But if that's the kind of response we're going to get, it doesn't sound like they really touched the critical issues. So I don't know how useful it's going to be. Jay, let's talk about Zynga. You work for a very interesting company these days. We talked about Privacyville back in July when you launched it. And for folks who don't remember or didn't tune into that show, that is an online game, one of Zynga's many online game offerings. But this one walks you through the company's privacy policies and helps you understand what your rights are and how to protect them, and what you're agreeing to when you agree to play Zynga games. Very interesting and innovative idea, Jay. And I'm wondering what your experience has been with it since you launched it. Do you have any insights for us and any anecdotes that involve the privacy game?
We do. I think it's probably more fairly described as a game-like tutorial. The idea was to leverage familiar mechanics for users, but put it into an educational setting. It certainly wasn't intended to be a game like Cityville or Castleville, but it actually is based upon the Cityville mechanics. It was amusing to me to see some criticism saying it wasn't fun enough. It's like, okay.
Because otherwise privacy policies are so very fun, just all on their own.
So darn hilarious.
Yes.
But actually, let me tell you that why we did this and how it came up, because I think it's a little bit interesting. We had been thinking about, as many folks were thinking about, this historic challenge that, geez, these privacy policies, these terms of service are long and they're detailed, and God, we got to make them simpler for consumers. And we first did a privacy center, which was sort of the intermediate attempt. We had the policy, then we had the privacy center that had a more boiled down version of some of the content. And we were at a privacy conference, myself and a colleague, and one of the senior staffers from the FTC was there and said, I hear you, essentially said, paraphrasing, I hear you all talking about how hard it is to communicate privacy content to consumers, but you're in the marketing business. That's what you guys do. And my colleague and I looked at each other and he said, she's right about that. So we got thinking about ways we could do it. And my team, I think it really originated from other members of my team, said, well, why don't we do something that's like a game? And then it evolved to a game-like tutorial. So we put it together. You basically walk through buildings. You click on buildings. You get little snippets. Each snippet, of course, has a link that takes you to the full content, either in the privacy center or in the privacy policy itself. So what we found is we have millions and millions of views. We have found, I think we have, let me see, it's 90,000 likes, 90,000 Facebook likes connected to the Privacyville tutorial, which, the fact that you get anyone to actually like a privacy policy content I think is pretty cool.
Yeah, that's amazing.
Likes. We also found that as compared to our old privacy center, which we thought was like the state of the art, 25 times more access to Privacyville than the privacy center. So, I personally think this is a great success. Where I ultimately come out is, I think the concerns about long, detailed privacy policies are correct, but at the same time, there is so much going on in websites like ours in terms of data collection and things that a consumer might want to understand, or maybe a consumer watchdog group might want to see and understand. I think you need to have all that detail there, and a lot of it may go over the head of the ordinary consumer, but for many folks, they want the detail. And then there are folks that like the intermediate approach, and then there are those that are happy to have a simple tutorial to get a comfort level. So our approach of offering all three, to me, I think strikes a nice balance, and we're going to continue to innovate. One of the things that we're also trying to take to heart is the FTC's now relatively recent report talked a lot about privacy by design, meaning build in thinking about privacy during the design stage. Don't design the product and then, a week before launch say, geez, I wonder if we have any privacy issues here. So we actually do that, and we're trying to also do some creative things in what they called just-in-time notice. So that means you might have a disclosure in your privacy policy, but if during the consumer experience you're doing something or about to do something that some consumers might be surprised by or might not like or automatically think is a good thing, put some sort of notice right there. And I think that's the so-called just-in-time notice. And I think a lot of us in the industry are trying to do that. I mean, the one that we're all familiar with is, we're about to track your location, which Apple does. But we think there are some other areas where that can be done sort of elegantly in a way that ultimately helps with consumer satisfaction with the product.
Right. The last thing you want to do is upset somebody's expectation or the context that they have in their head that may be counter to what's actually happening on the site. And when they find that out, that's when you have your trust and everything else compromised. Beatmaster in our IRC is wondering whether you feel like Zynga has cleared that hurdle or is, day by day struggling to make sure that it's maintaining the trust of its users.
I really do think that we have, and I agree with your point, because no matter what our privacy policy says, no matter what the terms of service say, if you do something that upsets or surprises an inordinate number of your audience, then you failed at some level, and we want to avoid that from a good customer point of view. We were in the news a little bit, a year and a half ago in connection with privacy, really because of a series of Wall Street Journal articles, and out of those articles came several class action lawsuits, all of which basically made the same claim. And the facts of the case and the facts of the article had to do with transmitting the Facebook ID from Facebook into the iframe where the game exists. And Facebook ID is actually public information. The lawsuits are not going very well for the plaintiffs. They sued Facebook and us. Most of their claims were dismissed, and the claims that they still have left, I think they're barely hanging on to even stating a cause of action. So it's unfortunate we had to go through that, but all of this certainly heightens sensitivity in the industry and within the company. Privacy is a deadly serious topic. In fact, the last thing I'll say is when we launched Privacyville, we also did a company launch that was sort of a celebrated launch where we sent out an email, invited everyone in the company to use the tutorial, and we made T-shirts that were distributed to every person in the company that had the Privacyville logo, and then on the back it says, "Where privacy is no game." And we continue to trumpet to all folks in the company that privacy and protecting user privacy is everybody's responsibility, no matter what you do.
That's fantastic, Jay. It's great to hear, and it's wonderful that I've been following along because I have a youngster and am in the process of seeing what works well from a learning standpoint. So I've been paying a lot of attention to using game mechanics and learning, and there's a lot of scholarship around that and a lot of folks who think that it's really the way to go. So it's wonderful that you tapped into that, and I love the notion of just-in-time notices. I think we're seeing good examples of how that can play out in Google Plus and elsewhere. It's good to hear you guys doing that stuff too. Kevin, any questions or comments about all of this?
No, I think that Jay did a good job summarizing, what it is that his company does, and certainly respect their stance toward privacy. I think it's wonderful that the company is taking the privacy of their users dead seriously. I mean, I'm a happy Zynga user myself, although I'm much more of a words with friends person than some of those other farming type games. But I'm just very, very happy that they're taking these things so seriously.
Yeah, it is good to hear. Jay, you guys just had your Unleashed event with a whole bunch of.
That?
Sorry, what just happened?
I'm sorry. Can you see that on the screen? That's
one second.
My personal. That's my personal words with friends. Letter J. That sorry, I couldn't resist the plug for Words with Friends. Sorry.
That's amazing.
Oh, that's awesome.
You guys just had your Unleashed event, and where you released a lot of stuff. So all the things that you're rolling out now, are they being influenced by this approach of privacy by design?
Absolutely. And what privacy design means is that for every single game, somebody from my team is involved at a very early stage. We also had to establish what we call the privacy sentinels, and these are basically people that work in the different groups that are sort of our privacy posse. And so we deliver information through them, and we get information from them in addition to all of our all of our other activities. I mean, the challenge of a growing company, when you're small, like early eBay, there were 200 people and they all sort of sat right in front of me. When you get larger, you're in multiple buildings, multiple cities, multiple countries, you've got to have a posse out there of people that are educated, know what the red flag signs are, and will pick up the phone or email and contact you when they think there's an issue.
So Jay, this all sounds wonderful, and I'm just wondering, actually, Beatmaster in IRC is asking some good questions about how this influences your business partners, the folks who help you monetize the games. Are they on board with all this, or do you find them getting impatient with your attention to privacy and making sure that user expectations are met?
I mean, usually it's not a problem. Where there may be some friction sort of for folks in our position is with advertisers who probably would love to have a lot more information about our users, and we don't provide that information. I think most others don't provide that information. That's in our privacy policy. I mean, our interest is providing the best consumer experience, and in some cases having ads targeted in the right way to you as a consumer is actually a better user experience, because if you, for example, remove cookies and you end up getting non-targeted ads, which are, I keep getting the over 40 overweight ads for some reason. But in any event, we're certainly holding the line on that, and I think if anything, we would move in a direction of providing less information in the sense that you would not be able to target a specific game, or you wouldn't be able to connect users across games. And there are some industry issues on how to actually do that, and I think advertisers are going to have to face up that we as operators of businesses with consumers are increasingly in a good position to deliver a good customized experience without sharing lots of information with third parties. By the way, on the ad front, we have very, very few ads on our site. I don't want to overemphasize the issue. The vast majority of our revenue comes from virtual goods. So I just know that there has been discussion at an industry level continuing about advertisers and the sorts of information that they have or would like to have. Right.
So, Matt, any thoughts on any of this or questions for Jay before we move on?
No, I think it's great that in a totally different context, I deal with a lot of the same issues when I have a client that is working on, products and everything, and kind of dealing with things early and upfront, whether it's when the initial design stages throughout separate phases in the design before you get to product, really dealing with these legal issues and the potential ramifications of what you're doing early on. It's a strategy I think works very well, and interested to see how it works out there.
All right, well, for our last story before we get to our tip and resource of the week, I just couldn't resist throwing in something from Eric Gardner over at The Hollywood Reporter Esquire. We're a little late for Halloween, but he has a fun story. He was right on time. This was from October 30th about Power Rangers Halloween costumes and how the company that owns the rights to Power Rangers were going after, let's see, they're called SCG Power Rangers LLC, filed a suit against Underdog Endeavors, operators of MyPartyShirt.com, who have some very funky-looking Power Rangers costumes. And it raises the question that, you see all over at Halloween. You assume that those various character costumes are licensed in one way or another, but you realize they can't all be, they call each other, or they call themselves something other than the official name for the character they are meaning to evoke. So the fashion industry, of course, has its share of issues about copy protection related to clothing design. But right now, the Copyright Act doesn't permit a useful article such as clothing to be copyrighted. But the things that can go along with the packaging for a costume, the pictorial graphic or other things, could definitely be subject to copyright protection, and of course the design aspects of the costume itself. So as you digest your Halloween candy, it's fun to think about that issue and whether we're going to see more suits over Halloween costumes. Matt, did you take a look at this, and did you use any licensed characters in your Halloween festivities this year?
Oh, I'm sure. The best one I saw is this little kid with a UPS outfit on. That was like the best costume I've ever seen. But do any of these companies, and again, this is outside of what I do on a day-to-day basis, but do any of the companies ever assert trade dress issues over some of these costumes, or even if it's some other article besides clothing?
They do.
Go ahead, Kevin. Yes?
Yes, I do represent some children's entertainment companies that have asserted trade dress and trademark rights to go against costumes.
And how's that going?
It's been a few years, but the last case was very successful. I have some remnants of an old costume in my office as a trophy.
There you go. Yeah, lawyers love to have little mementos like that around the office, be they tiles or costumes or.
Oh, see, mine's boring. When you win a patent case, it's you get like a chip set or a something boring.
I have a slinky from Eric Goldman. That's my latest prized possession.
Yeah,
in fact, Denise,
that's it behind me.
Denise,
that's way more fun.
Denise, I was gonna add that having worked for Disney, I certainly have sympathy for the desire to protect characters, and it's not for them. It's obviously partly a licensing issue, but I think it's equally the concern that somebody puts together a Mickey Mouse costume, which is poorly done. And it reflects negatively on the brand. So it's about brand control as much as it's about licensing. And I think something like Mickey Mouse, you could have a mouse costume. At what point is it a functional element? You're going to have big ears. You're going to have a certain tail. So I think it's going to bring in all of the classic copyright issues of merger doctrine and functionality and those sorts of things. And I know that there has been recent litigation in Europe, specifically in the UK, involving the protectability of the Star Wars helmets. And my understanding is that they have successfully protected those, meaning they've shown that there are elements that are not purely functional in the US, but have had a tougher time in the UK. So I'm sure that these costumes, under some theory, might be protectable, but for something like Power Rangers, I think there will be lots of arguments about sort of the generic things, or sort of the scenes of fare, using that doctrine, the scenes of fare things that you see in an action figure or a superhero or that sort of thing.
Right. It seems like there would be some analogies to be made there. All right. Well, we have some great resources for you this week. One of them, going along with our discussion of the smartphone patent wars, is a great graphic, and I'm going to put it, it's a long URL. I will put it in the discussion points for the show at delicious.com/thisweekinlaw/136. It's from the Financial Times. Ayaz Akhtar, in the studio and of our great Ion show, told me about this. And it is this wonderful interactive graphic that shows you who's suing whom and what's going on in all of the various smartphone patent lawsuits. So, yes, if you're someone who's playing along at home and trying to figure all of this out, it's done very nicely, and it will give you much aid and guidance. And then something a little bit less esoteric, more practical, also as a resource for you, is the I'm Getting Arrested app in the Android marketplace, which alerts your lawyers, loved ones, et cetera, if you are being arrested. I have to go back and listen to our shows, because I think maybe as we were discussing the Occupy Wall Street stuff, we came up with the idea for this app, but obviously we're not the only ones, because somebody has put it out in the Android market. and it was inspired by a real Occupy Wall Street incident. It says it's free to the other 99%. So there you go. If you want to be able to quickly tell people that you're getting arrested, that app is going to help you out. Now, our tip of the week has to do with a lawsuit. A student is suing Facebook. People always wind up in conundrums like this, and the tip I'm going to take out of it is if you are a student, don't trash your teacher in your status updates using profanity and everything else. And the flip side of that tip is if you are a school district whose teacher has been trashed in such a way, then don't punish the kid because, people do have free speech rights in things that they're doing that have no connection whatsoever except for the subject matter to the school. So there is this lawsuit pending. The kid was punished. He's suing the school for punishing him over his Facebook status update, which he thought was locked down and privacy protected. His expectations of privacy were upended, however, and the status update got out, not just back to the teacher, but the district and the world at large, as we are discussing it here on TWiL. So do be careful with what you say on Facebook. And if you're a school, do be careful with what you do about what you hear on Facebook. And, we hear so much about cyberbullying and everything else. I'm seeing play out in my youngster's life that actually being online and having online tools available is for this generation helping them work out differences and disputes. And that's something that we don't hear much about as cyberbullying legislation and et cetera gets enacted and trotted out there to satisfy constituents. So that's our tip of the week. And that's going to be our show. I'm so thrilled to have had this great panel to bring to you today. Jay Monahan, thank you so much for joining us. And congratulations so much on the Vanguard Award you're going to receive next Friday while we're recording TWiL. Otherwise, you're going to be right down the road for me. I would love to be able to go, but I'll be there in spirit instead. You and Professor Goldman and Judge Kaczynski and some wonderful, wonderful folks have been honored with the Vanguard Award, and we're thrilled to see you up there this year. So thanks so much for joining us today, and good luck in all your endeavors.
Great. Thanks for having me on. It was fun. It's
been really fun. And Matt, wonderful to have you back. Congratulations again on The Verge.
Oh, thanks. No, it's been a blast. Thanks for having me on again.
Our pleasure, and wonderful insights. We're going to continue to drag you in here to help us understand what's going on in the patent arena from time to time. We hope you don't mind.
Oh, I love it. Yeah, as long as I don't have to talk about other things, I'm good.
Just fine. And Kevin Thompson, thanks so much for joining us again.
Well, thanks so much for having me, Denise. It's always a pleasure to be on, even on short notice.
Yes, absolutely. We appreciate it. We wish Evan the best as he recovers from his laryngitis. And we wish you all a happy weekend. And definitely check us out after the show. We distribute the show at twit.tv/TWiL and on YouTube and on Roku and various means. And tune in live while we record. That's at twit.tv at 11 o'clock Pacific time every Friday. We'd love to have you tune in. Whichever way you do, we'd love to have you get in touch. Between the shows, you can hit me up at Denise at twit.tv, or I'm at Howell on Twitter, or I'm over on Google+, and I monitor all those things, so let me know what's on your mind. It helps us get topics, and we love to hear from you. Thanks so much, and we'll see you next week on This Week in Law.